Hello friends, welcome back to my channel. In the series of Indian Penal Code, we are discussing general exception and we already covered section 76 and 79 of Indian Penal Code. In this video, we are going to discuss some more general exception, that is section 80 and section 82 and 83, which is talking about the accident and infancy respectively. But before going further, I would like you to please like, share, and subscribe my channel for more videos. And if you are not watch my previous video, please watch it and then watch this for better understanding. Thank you.
In everyday life, there is a many events which took place on which the person had no control over and which he couldn't avoid despite the due diligence and care. So, can you say that that person commit any offense or he can be punished for that? So, the answer is no. Because according to the criminal law, the only act which is treated as an offense when it is done with a criminal knowledge and criminal guilty. So basically, when any act committed on which the person has no intention, criminal intention basically, or knowledge to do that act to commit any harm to another person, then he must be excused under Indian Penal Code for such offences. So, if any act is conducted, then he can be excused in Section 80 of Indian Penal Code. So, what is accident? The term accident is taken from the Latin term that is accidere, which means that sudden act. When any actor or event which occur all of a sudden and no person could anticipate or foresee or even expect it, that such a reaction or such act is done, so the person can be taken a defense under this section. But to prove that such act is just an accident and nothing else, then it must be proved that the accident is done with misfortune. So you have all question that what is misfortune then? So the misfortune means the unfortunate mishappening incident. The both words are similar, but there is a little difference between both of them. That the accident is only caused the injury to another person, but in misfortune, the accused person also receives some types of injury. So, any action that occurred without intention and knowledge of that person, and some any act, yeah, event which the person has no control over, or after the due diligence and caution and care, he can't avoid it, then the person can take defense in this section. For example, in a cricket game, if a batsman hit a ball which unfortunately strike a man on his head and he dies instantly, then such person has not commit any act because they the act done without the intention and knowledge to commit any murder. Even the batsman basically has no control over that actor, and after the due diligence and care, he can't avoid it. Then he can take an advantage of this section of which is accident.
Now look at the Barrack language of section 80. It says that nothing is an offense which is done by the accident or a misfortune and without any criminal intention or a knowledge, in a doing of a lawful act in a lawful manner by the lawful means and with the proper care and caution. So there are some ingredients which must be proved before the court, and if the court is satisfied, then the person can take a defense under this section. Suppose A shoot at the owl sitting on the bush with the intention to kill it, but instead of the killing a owl, they kill a bee by accident because it is they have no criminal intention or a knowledge to kill the bee, so it is commit no offense, but it's all and we take an advantage of this section. Now it's time but look at the essential ingredient of the section 80. The first one is the act must be done by an accident or a misfortune. It means that if any incident or mishappening done and it is in such a nature that the person can't control it, and even the person can't foresee or expect it, so the person can take an advantage of the this section, but it must be proved before the court that there is no negligence or the carelessness on his part. Now, the second one is without the criminal intention or a knowledge. In the criminal jurisprudence, it is presumed that the man know the nature and the consequences of his act and is responsible for it. And if any person commit any act without such criminal intention or knowledge, then they can't be punished for it. Because to commit any criminal act, there is an important ingredient, that is a mens rea, and if it is absent, then the person can't be stated as he is a criminal person. Now the third one is lawful act in a lawful manner by the lawful mean. It means that when even the act is done incidentally, or the person has no control over it, but it must be a lawful act, and done in the lawful manner by the lawful mean. Suppose a woman who trying to teach her child a discipline and hit her with an iron rod, but instead of hitting her, they hit another child and they got injury. Because the act is not a lawful act and not done in a lawful manner, then the woman can't take an advantage under this section. And the last ingredient is with the proper care and caution. It means that when the act is done, which is a lawful act, but with a done with a proper care and caution, and trying to not harm another person, but incidentally they took a harm, or they harm which is not intentional. So basically, the all four ingredients must be proved before taking the advantage under this section. But until the court presumed that all these circumstances in the is absent, until the accused person has give a chance, take a chance to prove before the court that these ingredients of section 80 is present at the time of the incident. But to avail the benefit of this section, it is necessary for the accused person to prove before the court that there is no criminal intention and knowledge of that person to commit any act which is now become an crime. Now look at some case law for better understanding. The first case is Sukhdev Singh versus State of Delhi 2003. In this case, the accused person pleaded before the court that while doing the lawful act, he accidentally committed a murder of the deceased. But the evidence showed that the accused person in the fight deliberately used a gun and fire shoot at the person. So the Supreme Court held that it is not a case of the accident because the person has a criminal intention at that time. The second case is Jogeshwar versus Imperial. In this case, the accused was giving a fist blow to the victim but accidentally hit a wife who is holding the 2 month of child. Because the blow hit the child, which is the result of his death. The court held that the act is not a lawful act and it's not done in the lawful manner, so the person can't take an advantage under this section. The last case is Bhupender Singh versus State of Gujarat 1998. In this case, the person at the time of the supervision of inspecting the dam site in the dusky hour killed a person. In the before the court, he appealed that because of the dark at the time and they can't see the anything. And even when they shout to stop the person can't respond it. Then he shoot the fire the shoot. But in the evidence, it is proved that the fire was done from the close range. And because they can't see before the close range, they can't take an advantage under this section because they did not take precautions before firing the shot and was held liable for such offense. Now we are going to deal with section 82 and 83 of Indian Penal Code, which talks about the infancy. The term infancy means a childhood, and when the child below the age of 7 years or below the majority age, they are treated as an infant, and it is believed in the law that because the child is innocent and they don't know what is right and what is wrong for them, and because of there is no mens rea in them, any wrongful act which is done by the child is not treated as an offense. In India, there's a many laws which talks about the infancy rights, and because they are immune from the criminal liability under section 82 and 83 of Indian Penal Code also. In the Supreme Court case of Gopinath Ghosh versus State of West Bengal, the Supreme Court first time raised the defense of infancy. They are first time talk about them. Now look at the section 82 first. Section 82 talks about deals with a act done by the child below the age of 7 years, which means that in law or in a IPC, if any act which is committed by the 7 years of age child or below the 7 years of age child, it is not treated as an offense. This concept is basically derived from the Latin term that is a Doli Incapax, which means incapable of doing harm. Because it is believed in the law or in India that the child below the age of 7 years, the child can't distinguish between the what is right and what is wrong for them, and they have also have no mental capacity to understand the nature and the consequences. So they are exempt from such type of criminal activity despite the how the serious the act are. But if any person who is mature enough and know the nature and the consequences of his act, and they abet a child to commit any crime, then they are responsible and held liable for as an abetter, but the child can't be held liable for that offense. There are some case laws which deal with Section 82. The first one is Shyam Bahadur Karai versus State of Bihar. In this case, the child below the age of 7 years discovered the gold plate which is weighted 28 tolas. After recovering it, he didn't report to the collector. When the collector know about this incident, he ordered the prosecution for the child, but the court acquitted the child because they have a benefit of Section 82 of Indian Penal Code, which talks about the Doli Incapax. The next section is March versus Lauder in 1863. In this case, the child below the age of 7 years stole a piece of wood. The defendant, uh, when they catch the child, they gave him the custody of police custody. Because the child is under the age of 7 years, they can't understand his action, and he could not be liable for such offense or such charges also. Now, Section 83 talks about the act done by the child above the age of 7 years and below the 12 years and with a immaturity understanding. The section says that nothing is an offense which is done by a child above the age of 7 years and under 12, and who has not attained the sufficient maturity of understanding to judge the nature and the consequences of his act on that occasion. The whole concept of this section based on a maxim that is a Doli capes. It means that the capable of a wrongdoing. But there is a one point which must to prove or taken a defense is that if the child have no maturity level to understand the nature and the consequences of his act, then he can't be held liable for that. And if the prosecutor trying to convict the child under for the any crime, so they has to prove that the child at the time of commission of act has a criminal intention and knew the nature and the consequences of his act. To availing the Section 80 benefit of Section 83, there are some essential. The first one is the act must be done by the child, and the age of the child must be between 7 years to 12 years, and there must be a lack of sufficient maturity to understand the nature and the consequences of his act. And the term nature and the consequences of his act means that there must be a natural consequences and not a penal consequences. And to take a benefit of under this section, it's all depend upon the fact and the circumstances of each case, and each case means that the every child has their maturity level. So if the child gain such maturity level, then they are punished for that offense. But if they are not sufficient to understand the nature and the consequences of his act, then he can't be punished for it. But the court have a correct criteria to understand or to differentiate between the child that such child has a sufficient maturity or not. The first one is the act must be committed by the child. Second one is the subsequent act after the commission of the act. What are the subsequent act which is a child committed after such act? And third one is appearance of the child before the court. To understand Section 80 more clearly, we look at the case laws. The first one is Santosh Roy versus State of West Bengal 1982. In this case, the High Court of the Kolkata stated that the witness statement of the child whose age between the 7 years to 12 years can't be directly ignored by the court on the basis of the Doli Incapax. Because in order to satisfy himself, the court has to be understand the has to find out the maturity level of the child, and for that the court may ask some questions from the child, but the court can't ignore the statement of such child in on the basis of the Doli Incapax. Next case is Kaku versus State of Himachal Pradesh 1976. In this case, the accused person whose age is 13 years has committed offense of rape on the 2 years child and was punished with a sentence of 4 years imprisonment, and which is after upheld by the High Court, and the court looks some circumstances and opinion that the punishment shall be reduced to 1 year and with a fine, and along with 6 month imprisonment more if there is a default in payment of fine. The convicted child also stated that he must be kept separate from the adult prisoners also. Thanks for watching. If you like my videos, please hit the like button. And if you want to see such more videos, please subscribe my channel for more such updates. And if you want to say something, please leave the comment. I will appreciate it. Thank you.